So welcome everyone. Welcome to 2.420 or not 2.420. That is the question. This is a CLE program offered as a partnership between the Florida Bar, the Trial Lawyers Section, and the Florida Court Clerks and Comptrollers. I'm Carolyn Timon, the Clerk of the Circuit Court and Comptroller for Martin County, and also the current president of the Florida Court Clerks and Comptrollers, our professional association. Florida's clerks of courts really appreciate this opportunity to provide a program which, quite honestly, benefits the clerks as well as the Florida Bar and its members. But ultimately, this will also help protect our shared public, your clients and our constituents. We also appreciate the spirit of collegiality when we identify issues that are important to all of us. For this program, I especially want to thank the current president of the Florida Bar, Gary Lesser, along with Board of Governors member Braxton Gillum, for listening to the concerns of the clerks and helping to facilitate this presentation. We have a lot of information to discuss, so with that, let's get started. Since the development of this presentation involves some very conscientious attorneys, disclaimer language is important. Please take a moment to review it on the screen. Besides myself, the presenters for this program are the Honorable Greg Harrell, Clerk of the Circuit Court and Comptroller for Marion County, the Honorable Laura Roth, Clerk of the Circuit Court for Volusia County, Amy Borman, Chief Legal Officer and Chief Operating Officer for the Office of the Clerk of the Circuit Court and Comptroller for Palm Beach County, and Tom Hall, Appellate Lawyer of Counsel with Bishop and Mills and former Clerk of the Supreme Court of Florida. As we progress, each presenter will open with one or more quick survey questions. These will pop up on your screen, and please select your responses as quickly as possible. The final results will be tabulated when the survey closes. We will not be collecting your names, so don't hold back on your responses. The presenter may or may not provide an answer at that time. As I understand it, the attorneys are familiar with this style from their fondly remembered law school professors. Some survey questions will also help us gauge your interest or general understanding as a topic to help us in the future. Each of the presenters will also provide time for questions at the end of their section. If you have a question, please submit it using the Q&A feature at the bottom of your screen. Then, if time permits, we'll also provide an opportunity for questions at the conclusion of the full presentation. What we're primarily talking about today is the governance and processes related to access to sensitive or confidential information within court files. We'll discuss the applicable court rules, Florida statutes and case law, and how they relate to the practice of law and to access to court records. You may be wondering why there seems to be a sense of urgency surrounding these topics. So I hope I can help set the stage for you. Those of you who've been practicing for probably more than 10 years may fondly recall visiting the clerk's office to thumb through a non-confidential paper file. I've even heard that sometimes attorneys could borrow the file and make their own copies, and there may or may not have been redactions to documents within that file. We also had fairly open access for the press. Daily filings would usually sit in a basket on the clerk's counter, and a reporter would show up daily to see what was going on in the community. The press seemed to have an unspoken code, at least I know they did in my community, and wouldn't print names of victims of sexual violence, information about children, banking or account information, or social security numbers. Then, to meet access demands and reporting needs of the judiciary and other stakeholders, as well as to increase accuracy and efficiency, robust electronic case maintenance systems were launched across the state in the clerk's offices in about 2013. And I really have to add here, there are not 67 different systems. There are fewer than 10 different systems, several of which are in-house products or consolidated systems across a county or even a circuit for multiple judicial partners to utilize. That brings us to the access issue. Judicial, clerk, attorney, governmental agencies, law enforcement, press, and the public. Each entity has a defined access role based upon their role as determined by the Florida Supreme Court following significant review and input. With the surge in technology came a corresponding surge in the gathering and sharing of all kinds of personal or confidential information. For instance, those in the legal profession may be curious about similar cases or results. Mass media routinely seeks and may create publications for sale that contain mass case data and images. Today's beat reporters are trolling all day for case updates in a much more competitive market, and they may use exactly what they see: unredacted, sensitive, or protected information. Another frightening side effect of increased technology, electronic access, and anonymous viewing is the criminal element. In particular, identity theft and the use of personal information to seduce individuals into various scams. The Florida Supreme Court quickly acted to develop rules to govern online access to court records. Our panel of experts will walk you through the development, implementation, and impact of these rules on your profession and sometimes on you personally. Changes to Rule 2.420 brought about the opportunity to share this information. Recently, when changes were made to the access rules, the Office of the State Court Administrator, OSCA, the Florida Court Clerks and Comptrollers, and the Florida Bar partnered to leverage their resources to get the word out to the legal community. We use social media, website posts, printed materials, and presentations. Fairly quickly, clerks noticed a general lack of full compliance with the access rules, which primarily affected civil cases. We cared about this for several reasons: our own liability, the review and redaction workload, and protecting our community from the public release of their confidential or protected personal information. Along with the redaction process and resulting labor and technology costs came a delay in access to court records, which impacted the judiciary, attorneys, businesses, and the press. So stay tuned during this presentation as our speakers discuss case law and rule changes, particularly those impacting civil cases, that resulted from actual or perceived delays in access. In February 2021, the Manatee, Marion, Martin, Palm Beach, and Volusia clerks of court offices conducted a one-week study of case filings. Among the filed documents subject to the rule change, 21% of documents filed contained confidential information that was not redacted or notified or flagged for redaction by the filer. So let's look at these composite numbers. Of the 46,853 filings in those 5 counties during that test period, only 500 included a notice of confidential information, and clerks redacted an additional 9,835 documents. Based upon our experience, we feel comfortable that these results would be consistent if extrapolated across the state. So I'll pause here for just a moment so you can think about that. 2 clerks' offices, mine in Martin and the Sarasota clerk, analyzed the compliance rates in civil cases to gauge the scope of the problem and to help guide possible solutions. So let's review those survey results. There were 597 notices of confidential information filed, of which 508 were not fully compliant for reasons ranging from not specifying the exact location of the confidential information to incorrectly applying the minimization rule. As a courtesy, and because we were analyzing those cases, the clerks applied redaction in an additional 1,680 documents and 32,964 pages needed redaction. So please try to remember the scope of that general volume of documents that required redaction without compliant notices as we move through our presentation today. Recently, I checked back in on our compliance data and unfortunately did not see tremendous positive motivation or movement forward. So shortly thereafter, all Florida clerks experienced a tremendous surge in civil tort filings in a very short time period. Remember that? So from March 17th through 24th, 2023, my office tracked the number of notices of confidentiality filed for our 607 new civil case filings just during that week period. Many of those filings that may have contained protected information were not filed in conjunction with a notice of confidential information or a motion to determine confidentiality. We had only 9 notices filed, none of which were compliant or fully compliant. To put this in perspective, there were a total of 1,949 documents, which included 6,555 pages filed during that time period that were not required to be reviewed by the clerk's office for potential redactions. Likewise, during the same time period, the Palm Beach County Clerk's Office reported that 7,851 new civil cases were filed. There, only 97 companion notices of confidential information were filed. Yet 12 of those were not fully compliant with the rule. Are you fully confident that the other 7,754 cases did not contain any confidential information? So I hope you're beginning to understand why Florida clerks of court are so concerned. You'll be hearing more about what happens when most of these civil filings without corresponding notices. But here's a little teaser. Depending on the specific case type, they may be immediately posted online in their as-filed format, unredacted, through the Florida Courts e-portal. In many clerks' offices, they may also be subject to automatic intake and docketing, again, as is. I should probably give you a moment to absorb that information, but instead, I think we're going to forge ahead to hopefully help mitigate this situation in the future. Each of our presenters will focus on a portion of the history, content, and impact of the applicable rules, primarily as they relate to civil cases, but also recognizing that unless otherwise specified, they may also relate to criminal and other case types. So just for a quick moment, does anyone have any questions on this first opening portion? Seeing none, I would like to now introduce Clerk Laura Roth, Clerk of the Circuit Court for Volusia County. Thank you, Laura.
Timmon,
Yes.
We had one question just come
Oh,
through.
we do. Okay. Go ahead, Patrick.
So it says, do your civil case statistics include family court filings?
No, not for the purposes of this survey. They do not. This would be primarily regular circuit civil, small claims, and county court.
Okay.
Any other questions, Patrick?
No other questions at this time.
Okay, great. Thank you. Clerk Roth?
Thank you. I appreciate it. Okay, so my name is Laura Roth, and I'm the clerk of court for Volusia County, as said. Okay, so we're going to start out with a survey question. If we can go to the survey slide. So the question to all of you is, when it comes to including social security numbers in court documents, according to the rules in Florida, the attorney should, and you're going to choose the best answer. Should you A, only include the last 4 digits of the social security number? B, not include any part of a social security number in a court document? C, include the entire social security number. The clerk must find it and redact it. Or D, set a hearing. The court must rule on whether the social security number can be included. So we will give you all this survey question to complete. Here it is. So please choose one of these answers. Please participate with your best understanding today. Okay, I don't know generally how long it takes people to do that. Do we have a fair number of responses? We're going to show the results once we close the survey. Is that long enough for everyone? Okay, I would think we could close the survey question. Okay, so our results are that 36% of you believe that you should only include the last 4 digits of a social security number. 57% believe you should not include any part of, and then a small percentage of 5, and then only 1% for the last answer. Okay, that's interesting. Thank you all very much, and pretty good answers there. as we go through my presentation, we'll come to understand the proper answer and why that's so relevant. Okay, so the next slide, please. Okay, so my job today is to give you an overview of how we got here. So this is a little bit of history, but we're also going to go through the basics of how the rules are expected and to operate and how this should work. And this is despite the change that you'll learn about later, which is very relevant and highlights the dangers out there if you don't comply. We'll get to the changes that happen to certain civil case types. But for right now, for our purposes, we're just going to go through what exists, what has existed all this time up to the change, okay? So there are generally 4 categories people look to when considering confidential or exempt information in Florida and as it applies to court records. The first one that might spring to mind is where you would look generally, Chapter 119 in Florida statutes, and there are other statutory exemptions and confidentialities in other statutes, but the vast majority are contained in Chapter 119. So as a shorthand, we're going to say Chapter 119, but I understand there are other statutory exemptions. So when it comes to those, put it this way, you look to Chapter 119 to answer the question, is information, is whatever it is you're dealing with, actually confidential or exempt in Florida? Now, remember, in Chapter 119 and other statutory provisions, there are over 1,000, well over 1,000 statutory exemptions or information made confidential by law. Second place is Rule 2.420, the basis of most of our discussion today, of the Florida Rules of General Practice and Judicial Administration. And this is subtitled Public Access to and Protection of Judicial Branch Records. Now, this rule answers the more relevant question of, is it confidential and or exempt in court records? And if so, how? So your answer to the first one, is it confidential under Chapter 119, does not stop the inquiry for litigants and practitioners and attorneys. You must then ask, but is it confidential and or exempt in court records? And if so, how? And we'll get into that. There are 2 ways those are treated under 2.420 when you've answered that question. Some maybe the answer is yes, they are, and it only requires a notice of confidential information be filed by the attorney. And then in some, a motion is required to determine the confidentiality of anything that is not included in Rule 2.420. We'll teach you much more about that. One of the future speakers will go into much more detail. Now, Rule 2.425, a sadly very little known, not often paid attention to rule in our experience, is also very well connected to 2.420, and I'll show you some demonstration of that. And this rule answers the question. So you might have yes under number 1, it is confidential or exempt in Florida. Under 2, well, yes, is it confidential or exempt in court records? But 2.425 answers, should it be included in your court filing at all? Should you even be including it? And then lastly, it's kind of a niche subject, but there is a special rule that handles the nuanced situation of Marsy's law or criminal victim information filing. So that question really is, well, what if I have victim information? How is it protected in court records? Okay, so we'll move on. Thank you. Okay, so why is it? I'm hoping some of you might be asking, well, why on earth, if you've already said at step 1 that something is confidential and exempt under Florida law according to Chapter 119, then why would it be that I can't rely on that as automatically applying to court records? How is that not the clerk's problem? Because clearly it's exempt or confidential by law. Well, the reason why is because quite some time ago, looks like in about 1995, the courts had ruled pretty clearly that Chapter 119 does not apply to court records. So we'll just read this language here. They held in this opinion, the Florida courts have long held that in recognizing the importance of the separation of powers doctrine, the term agency is used in Chapter 119 was intended to apply to the executive branch of agencies and their officers, citing Locke versus Hawks in 1992, and to local governmental entities and their officers, and specifically did not apply to clerks of the circuit court when acting under their authority, the authority of their powers under Article 5, which is judicial of the Florida Constitution. So in essence, the court here was saying Chapter 119 and statutory exemptions are intended for the executive branch and local government entities, and not to clerks of court, which is another way of saying, and not to court records, as we are the official custodian of all court records. So what does that mean in essence? Since the time that opinion's been published, it's been very clear to all of us that information protected under Chapter 119 is not automatically protected in a court file. So just because some information in one of your filings is protected by statute or 119, you may not assume that that means it is confidential or exempt in court records, and you may not assume that the clerk will therefore take care of it. The confidentiality of court records is actually governed by Rule 2.420. So we'll go on to that slide. So how that really happened in history, I'm going to try to make this brief because it went on for many, many years. And I was fortunate enough to attend a lot of the early meetings starting in about 2004. So back then, as technology was starting and clerks were very progressive and having records online, we wanted to harness that technology and get at and give access to these records as we're looked to provide them very often. So there was a boom and a lot of court information being released as people aggressively pursued technology advancements and releasing document images. So the courts began to struggle quickly with the competing interests of privacy versus access, knowing there would be confidential and sensitive information in many court documents. So let me just read you some language from the opinion back from 2010, where the scheme of how to handle this and make online documents possible was dealt with by the court after many, many years of committee meetings and numerous arguments in front of the Supreme Court back in 2010. And this is what they said. They said there were two committees ongoing at the time, a privacy committee and an access committee. You know, those were ultimately joined and they became a whole nother standing commission, actually. But at the time, there were these two different groups sort of battling both sides of the argument. So in its report, when the Supreme Court made its final decision how to handle the situation through 2.420 quite intentionally, they commented and reflected this is how they landed here. The Privacy Committee had concluded in its report, and I'm just going to summarize some of this, that the goal is to provide the public with electronic access to non-confidential court records when appropriate conditions are met. Thank goodness they adopted that goal, or none of you would have access to the records you do today through your clerk systems. Now, the Access Committee, on the other hand, was created to assist in establishing what are those conditions? What's a safe way we can do this? And one of the things the most central feature they had recognized is that they needed to narrow the scope of subdivision C8 of Rule 2.420, which at the time referred to any of the over 1,000 exemptions out there, okay? So they said, we've got to take these over 1,000 exemptions and get these more narrow to a finite set of public record exemptions that are appropriate for court records and are identifiable. Back then, the logo of the day was, are they readily identifiable by clerks? As most of you can imagine, I would hope, having clerk of court, deputy clerks responsible for searching through every court record looking for potentially over 1,000 statutory exemptions is not feasible and would have prevented access to those records indefinitely. So therefore, there were many, many different voices in these committees. I do want you to know that it was not just clerks and the courts. It was not just an argument between the two of us, though we all did hash this over very enthusiastically. There were also many practicing attorneys from various different types of practice that were represented on these committees and were parts of these committees. There were also media representatives, media attorneys, even some that still today are still active in this line of work, were present back then, and agency partners. Just about anyone you can think of. It was a very comprehensive group, and the discussion went on for many years. But they did decide in the end that the ability to identify a finite set of public records exemptions to apply to court records was critical to ever being able to allow electronic access to court records. That's how 2.420 was born. These amendments, we adopted to procedures for the clerks to identify that narrow set. Remember, there are over 1,000. So next slide, we'll go ahead and look right at 2.420. So this is an older version because, like I said, further in this discussion, so put a pin in this, but further in this presentation today, you will learn more about what changed. We just think it'd be more relevant to you to understand the impact of what changed if you understood what was. So at the time in 2010, and what has governed us up until very recently, was this language right here. And basically what it meant was they gave the clerks of court authority to designate and maintain the confidentiality of any information contained in a court record that's described in these sections below. Now, it says all information described by C1 through C6. Those are 6 very specific things like unexecuted warrants that you'll find in Rule 2.420. I wouldn't worry about that too much. But in B, it says any information subject to C7 or C8. And basically that means any information that's currently confidential or exempt from section 119 Florida statutes but they said not all of them, that's over 1,000. They said only as specifically stated in any of the following statutes or as they may be amended or renumbered. And then they named, at the time it was 19. We started with 19 exemptions when this rule was first born. Now it is up to 23. So currently there are 23 specific current exemptions adopted by the court that apply to court records. So the basic upshot of this language is it did make a partnership, a dual role, if you will, for the fact that clerks these were considered readily identifiable by clerks. We had long been used to redacting certain information and we feel like we could find those relatively easily. So we have an independent authority to redact any information that's in these 23, only the ones in the 23 exemptions on our own. That's why even though earlier when President Timmons showed you those statistics on how many things came through and how many were redacted anyway, we are not bound by only when you have filed the notice or back then when this rule was written. So in all case types, you are supposed to file a notice because this rule goes on and tells you if it is one of the 23, you should notice the clerk, puts all the other parties on notice, notices the clerk. However, and then for those outside the 23 exemptions, you would have to do a motion, and we'll come into much more detail about that. But it's a dual responsibility. Clerks can catch it and redact it. However, you are supposed to file a notice. So up until very recently, in all of your case types, you could rely on clerks if you failed to file a notice to catch those 23 exemptions for you. But that has changed, and we'll get into that. Next slide, please. Okay, so this I don't want you to pay terribly too much attention to this because we'll go into much more specific detail about this later, but I just wanted to give you a visual for these are some general these are the 23 types of confidential information that clerks have a role in protecting with your help, supposed to be with the notice, but that we have an independent authority to protect under 2.420 currently. However, these are just broad categories just to give you a sense of it, like adoption files, social security numbers, child abuse and sexual offenses, etc. But there's much more detail about these in the actual rule. So make sure you're looking at the actual rule. Please don't rely on this slide as a way to guide your behavior. Okay, so those are the 23. Okay, so that's how 2.420 was originally set up to work, okay? Between notice, motion, the clerk having an independent duty. Now, along with 2.420, when it first came out, we instantly were seeing there was not much compliance with the notices and lots of information was coming through. So shortly thereafter, only a year after that 2010 opinion came out, another rule was created to be a companion with 2.420, and that's rule 2.425, one of my favorite, and it's called the minimization rule. Now, this is a quote from an actual article that came out in the Florida Bar News, May 2015, I believe. Litigation Practitioners Confusion. Florida Rule of Judicial Administration 2.420 and 2.425 and the improper filing of sensitive information. So this issue has been going on a long time, and they wrote about it in 2015. And they specifically say this minimization rule 2.425 was enacted as a new rule in 2011 to specify the format in which a party's sensitive information must be filed if it can be filed at all. Rule 2.420 and 2.425 are companions. So if you're glad that you're relatively familiar with 2.420, please ask yourselves, but have you considered 2.425 and are you following that rule? It serves as a companion and it provides the procedures for protecting personal information even being filed with the court, while 2.420 governs the procedures for confidentiality of information after it's been filed and for providing the public access to that non-confidential information. So you see how those work together. So he also noted in the article that 2.425 makes it clear that certain sensitive information cannot be filed with the court at all. And there's the answer. The majority of you did get it right for that first quiz question. There's your answer right there. They put in brackets like social security numbers. They cannot be filed with the court at all, according to the minimization rule. Those of you, the second runner-up on that question was the 4 digits, the last 4 digits, probably coming from a federal understanding, as I believe they handle it that way. But in Florida, not at all. Now, also, you could tell it still wasn't working because in 2013, they then enacted Rule 1.020 was enacted, and it provided that, and this is in the civil rules, but they reiterate again, every pleading or other paper filed with the court shall comply with 2.425, the minimization rule. So really, you've got 3 rules now putting you in this direction. Next slide, please. Okay, so because that one's so important and we find that it is very often neglected, we'd like to go over Rule 2.425. It was originally designed that if everyone complied with 2.425, there would be very little at issue in 2.420. Clerks would not be redacting as much. You wouldn't have to file as many notices, okay? So if you look at it here, it says limitation for court filings, unless authorized by somewhere else, designated sensitive information filed with the court must be limited to the following format. Now, really quick, understand clearly, please. Rule 2.425 is a rule for you as filers, you as attorneys, practitioners, litigants. This is not, it does not say the clerk shall make sure that whatever submitted, she should then reduce to the following. No, it does not. It is not our duty at all. And we were very clear on this in all the meetings and when it was created. I want to say this was maybe the brainchild of Paul Regensdorf. I don't know if he's on the call. So anyway, let's look at some of these examples. Number 1, the initials of a person known to be a minor. So there should not be full minors' names in your court pleadings. Were you aware of that? It should be initials only. The year of birth of a person's date. And then we really wanted to highlight, because we see last 4 of Social Securities very often, if I'm honest, we see that a lot. No portion of any following: Social Security, bank account, credit card, charge account, debit. We call those the Florida 5. Okay, so no portion of any. All right, next slide. Next part of that rule says you can put the last 4 digits of. They didn't include Social Security numbers, unfortunately. So you have that federal versus state disconnect, but you may include the last 4 digits of a TIN, an employee, EIN, a driver's license, passport. You can read the screen. So on these types of accounts, you may include the last 4 digits. And then next slide, I think it'll bring us to the end of 2.425. You can use a truncated version of any email address, a computer username, password, or personal identification number. So they don't expect you to give the full. On those, you can use a truncated version. It would not trigger us to redact, and it does not require a notice. And it says a truncated version of any other sensitive information is provided by court order. So if you can get the court to order that you only have to refer to some certain asset by a truncated version, you are welcome to do so. So please, if you're not, we urge you to become familiar with 2.425. And we'd love to see it that today after this call, there are no longer any portions of Social Security numbers, or if they must be included, that you filed a notice. Please don't try the last 4. That just can't work. We still have to redact, and you should be filing a notice. Okay. So next slide, please. And then lastly, I'm just going to go over briefly Marsy's law. The reason another rule was created, Rule 2.423, to cover criminal victim information with the passage of Marsy's law to the Florida Constitution. Why, what you might ask yourself, well, if you've already got the 23 automatic exemptions, somebody should redact this. Why didn't you just make it 24 under 2.420? Why didn't we just create line 24, criminal victim information, and we're done? Well, remember 2.420, except for certain case types you're going to learn about, 2.420 and that notice practice and the automatic authority of clerks to redact it gives the clerks that automatic responsibility, the responsibility to be identifying, because they're supposed to be readily identifiable, identifying on our own, even without notice, those 23 categories, just to be able to continue to release records online. They had to be ones we could easily find. Well, I have no bones to pick with criminal victims and definitely have compassion for that situation. However, criminal victim information, because it can be anything that identifies them or their location. Anything related to a criminal victim information could be throughout, especially in the criminal divisions, any document, anywhere, anytime. So if they had incorporated it into the Rule 24, it would have created an impossibility problem for clerks. It would have been a needle in a haystack in all criminal court divisions, and therefore would have shut down public access completely. So we reached a compromise here and said, why don't we do sort of a hybrid approach here? The clerk won't have an automatic authority unless noticed. So unlike 2.420, where it says you should still notice, but even if you fail to, don't worry about it, the clerk's got your back with that automatic duty. That does not exist when it comes to criminal victim information. This rule is set up that yes, the clerk will redact it if you notice us, but only if you notice us. There is no independent obligation. So please be aware of that. So if you look at this, we did arrange it because initial documents that start criminal cases are generally initiated by either law enforcement or the state attorney's office. So we knew we could partner with them and they would indicate for us on that initial charging document, whatever was filed to open the case, it could be their responsibility to put a Marsy's Law indicator saying that those rights had been invoked. And if they did so, then the clerk shall designate and maintain the confidentiality of that information only contained in that initial charging document, though. Even if they do it at the initial charging, it doesn't carry forward to the documents after, because again, we'd have that needle in a haystack problem. So therefore, except as in D1, the filer of any document shall ascertain whether it contains any confidential crime victim information. If they believe it does, the filer shall request that the information be maintained by contemporaneously filing a notice of confidential crime victim information within court filing. So if victim information, if you cannot use a generic indicator like victim 1, victim 2, and their specifics, you must file a notice with the document if Marsy's Law has been invoked. Okay. It says also, just like the minimization rule theory, filers of those subsequent court filings should just go ahead and limit the presence of the crime victim identifying information. So instead of having a separate rule like minimization, and they refer to it here as well, to ask you to please keep it out of your court documents, it's right here in 2.423. If you cannot limit the presence, it absolutely has to be in there, then you must file a notice of crime victim information within the court filing for each subsequent court filing. Okay. With crime victim information. And my last slide here is just a summary. So let's just kind of go over what we learned. And this is before the changes, don't forget. Okay, so you're going to learn how this has changed a tad. So chapter 119, these exemptions are not automatically protected in court records. They just aren't. 2.425, I do them backwards because this is how it should work. If you've got information that's 119, remember, not automatic for court records. So let me look to rule 2.425 first. How should I minimize it? It tells you what to minimize in that rule. So follow that. And we highlighted there, please remember, no part of a social security number. In rule 2.423, in rule 2.423, if you have criminal victim information, please remember there, limit it, and or you must file a notice or the clerk will not redact it. And then we land at 2.420. If you've passed all these and darn it, I really have to put this information in this pleading, then you've got two choices. If it's one of the 23, you just file a notice, we'll redact it. If it's not, you need to file a motion, and you'll learn much more about that with our next speaker. So thank you all. That's my section. I'll introduce. Do we have any questions?
Clerk Roth, hey, this is Patrick. We do have a couple of questions. So the first one is, may a redacted tax return be filed?
As long as my answer would be, and any other panelist is welcome to join, but as long as the tax information is redacted for those, for any information that's included in the minimization rule or anything that should be protected under the 23 exemptions, then yes, I believe the rest of the document could be filed as long as it's properly redacted.
Okay, can I just add one thing? So if you're filing it and you're listing your dependents' names, unless the court orders or a statute allows for the name to be there, you're supposed to minimize the initials of a minor. So in that case, you would just have to white out or block out if they're listing dependents, their names to initials. There are some times that you do need the child's or the minor's name, and when you read 2.425, it will say unless a court orders otherwise or a statute permits, because there are some circumstances where you would need it. But as Clerk Roth said, you just need to make sure that all of the confidential information or sensitive information is redacted.
Okay, next question. Is rule 2.425 for criminal cases as well? And does this apply to law enforcement as well?
My answer to that would be yes, it does apply to criminal cases as well. This doesn't really differentiate civil or criminal cases, although please do note in 2.420, there are some certain provisions later on, I want to say in sub F, that are specific to certain types of things in criminal cases. But anyway, I believe it applies to all. As far as law enforcement, that would depend on if it's going to become a court document. They do not govern your internal documents. These are court documents only. But if a law enforcement officer is actually filing something with the court, or it will be filed with the court, then yes, it would apply as well.
Clerk Roth, I'm sorry, can I just interject one other? Sure. What you said is a really good point, and I just want to make sure that those attending this understand that. 2.420 and 2.425 govern court records. So until it's in the court file, It's not a court record. So I always get questions, what if I'm exchanging with co-counsel? You can do whatever you want to do until it gets to a court record. So just remember, once it's filed with us, with the clerk's office, it becomes the court record. So just keep that in mind when you're thinking about, what do I have to do?
This is really exclusively for court records, which means they're filed with the clerk.
And I think Clerk Roth, one other additional point that might be helpful, because you had the law enforcement question, and back to Ms. Borman's comments as well. Law enforcement under 119, as Clerk Roth explained, may be able to redact certain things that before they provide those. However, those same things may not be protected in a court record. And we have those ongoing conversations with law enforcement to try to make sure that they understand that and don't inadvertently release information that they thought was protected.
Okay, we have about 5 or 6 more questions. So regarding the truncated emails, what exactly is a truncated version? Should emails be truncated from the front, the back, or the middle?
Yeah, I saw those two questions seem to go together. In my opinion, from the minimization rule, it is not specified. So however you want to truncate it. I'm unaware of anything setting a standard about that. Would that be easier? Patrick, I can see them as well.
Yeah, whatever you want to do. The next one is, what about subpoenas for banks and bank accounts, et cetera, and the notices that need to be filed?
Amy, would you like to help me with that one? I mean, if they're, like you said, is that an issue between parties? I mean, these rules only apply once this information would be filed with the court.
Yeah, so I would say that if you're issuing a subpoena and you're filing for some reason a copy of that subpoena in the court file, you have to be careful. But again, if there's a statute that says, especially in post-judgment collections, you're going to need, or the court may need, certain information, it's permitted. So if you're trying to deal with jurisdiction over a minor, you're supposed to include only certain portions of a birth date, but you may need all of it in order for the court to obtain that jurisdiction. So in those cases, it's permitted. So if you're dealing with subpoenas to banks, if you're just sending it out to the bank, you're going to have to put the account number, because how else could the bank respond? But if you file a notice saying, here's the return of the subpoena, then it's your obligation to make sure that that information is redacted. If you, for some reason, need it in there, then get a court order. But the biggest way I always explain this is, think about somebody that is culling through all of these court records, as Clerk Roth said, or Clerk Timmons said, for fraudulent purposes. I want to steal your identity. I want to take over your bank account. Why would we give them the keys to the kingdom? So think of it that way, of what you need to make sure is minimized, is not available for the bad person to see. So if you need it for the court, there's other ways of getting it in there. And you can exchange with counsel, with the banks, but once it's in the court record and it is an open file, think about who can see it.
Okay, next one is, can you file a check or bank account statement if you eliminate the account number and bank information?
Yes.
Okay. For filing a motion, usually whatever you want to file should be attached to that motion. So should the information be redacted from the proposed filing when the motion is filed, or should it be filed under seal?
You can ask, I mean, one thing is, if you read, I think we're going to get into this more in Amy's section. Could we defer, because there is more information coming later in the presentation about the details of a motion and how that would work. So could we hold
Sure,
on?
I'm going to save that. I'm not going to dismiss that one. I'll keep that active so we can I can get back to it.
Thank you. We'll come back to that one. Okay.
When an agency reports from the sheriff's offices, when agency reports from sheriff's offices are filed and the social security number is there, do the clerks redact ?
Agency, oh, it is a readily identifiable under the 23 automatic exemptions under 2.420. So if, as long as the clerk catches it or software catches it, it would be redacted. Just remember, there is a if you are filing into the court file, you have also a co-responsibility with the clerk to file a notice. So there's a notice for confidential information that Amy is going to teach you about soon in more detail, and it should be addressed in that way.
And can I just add one thing? There's, at least in our area, there's always been a belief that it's the law enforcement agency, they're not an attorney, they don't have to comply. It applies to filers, and if the definition of filer is in the rule. So if law enforcement is a filer, they have those obligations. So sometimes the law enforcement may want to talk to the state attorney's office about who files it, how it's filed, or have something set up, but it is the filer's responsibility, and judges are not considered filers. So there's another provision in that as well.
Yeah, we've got about 4 more questions. Does the prohibition on a minor's name and birth date in a court record apply to guardianship proceedings pertaining to the minor/ward?
Want me to take that? You would have to read the statute, and if the statute says you must provide the birth date and the full name of the minor, then you're covered. Because when you look at 2.425, it says no portion unless otherwise ordered by court, statute, case law, etc. So if the statute says you need it, then you're covered.
However, you're saying that they're covered, but they should still actually under 2.420 file a notice.
If you want that, well, the minor's name under 2.420 would not be one of the 23.
Right.
If
That's
there's
true.
anything dealing with their social security number or things like that, then yes, you would.
Gotcha. Okay.
So how does this
We got a
apply?
bunch of questions. You're more than 4. You got to keep
I
scrolling.
know, I really think a lot of them are, I mean, I think some of this is really going to be addressed in future sections. So we're kind of bleeding over now. You all want to keep going? Okay.
Oh, can I just answer one other thing? When we say filer, does this apply to electronic filers? It's any filers, not just electronic, it's paper filers as well.
Yeah.
So pro se litigants, self-represented litigants are under this, but it's a little bit more difficult to enforce that. So the clerk, especially when it comes in paper, we'll take a look, but they're under the same responsibility.
Yeah. Filers, no matter what format it comes in, if you're filing into the court.
And another just quick one on the notice of Social Security. Is the entire document confidential? No, it's just the Social Security number. There's a provision in there that talks about it's the least, the language is escaping me, but basically you have to make it the least, you have to eliminate the least amount. I can't think of the language, how the rule reads, but you can't make it more expansive.
So we have a few more questions, but did we just want to keep moving on and then see if maybe the rest of the presentation answers those? Okay.
Just from time perspective, I would say, yeah.
Yeah.
And I was also saying some of these we can answer as we go because we can type an answer to the person, and maybe some of us who aren't speaking can go in and answer them that way while the next speaker's talking.
Okay. All right. And so I'm now going to turn it over to Clerk Gregory Harrell to talk about the importance in the current situation. This is where it might get should get even more interesting. So Greg.
Thank you, Laura. Welcome everybody again. Good afternoon. Thank you for being patient with us. I know we're throwing a lot of material at you, but we appreciate the interactive nature of this and the questions. Now we get to sort of segue a little bit from where have we been, what has the lay of the land been, to really where are we now, and how did these more recent changes come about? Before we dive into that, we will go to our next question, R2, please. And I'm actually, you guys are mainly trial lawyers, I understand. So you think well on your feet. I'm going to throw a little bit of a curveball at you and change the word in this question from redact to protect. But what if it says, this is the question I want you to answer. In which of the following case types do you as a filer not have to protect confidential information prior to, or I would also add, or when filing a court record containing such information? Let's take a little bit of time to answer that question. Okay, let's go ahead and see where we are on that. Let's reveal the answers, please. There you go. Well done. All right, that's the majority, the lion's share, say none of the above. And that's because you as the filer, you all must have been listening to Clerk Roth. You do have an obligation to protect, whether it's through redaction or if on the list, filing a notice or a motion, okay? The next question, and this is where we're segueing into how things have changed. In which of the following case types does a clerk have an independent obligation to redact social security numbers and/or bank account numbers from a court record if you as the filer either do not do so or you do not file a corresponding notice of confidentiality? Okay, well, let's go ahead and see how folks did with this one. Okay, this one was a little bit of a trick question, and it's not none of the above. It used to be that the clerk had an independent obligation in each of those 4 different listed case types. As we're about to see and get into the changes, we now only have it under D, circuit civil medical malpractice cases. The onus is completely on the filer now for those first 3, which tees up nicely the section we're about to get into. Okay, next slide, please. All right, so we're just going to step on this slide briefly and keep moving. We're going to talk about the changes to the rule and then some litigation that actually affected some changes to the portal as you may know it as a filer. But before we do that, we're going to talk a little bit about the historical timeline and how we got there. All right. So now I know it's hard. We've all been through as Americans and Floridians the pandemic, and it's hard to even think in some ways about pre-pandemic happenings. But if you can sort of put your pre-COVID brains back in and think about 2018. In late 2018, the News Media Coalition shared with clerks' offices throughout the state a description of a tour that some of their members did throughout the state in various clerks' offices. They did not visit every clerk's office, but they sampled clerks' offices, essentially moving from the south upward through the north and through the panhandle. And what they did during these visits was they typically went into sort of front counter situations in clerks' offices and made records requests. Things like, I want to see all of your civil case filings from yesterday. What happened then was this report was shared with the Florida Supreme Court by an attorney for the News Media Coalition, well-respected attorney who has been involved in these issues for several years. And if we go to the next slide, we will see that from December 2018, when the calendar switched to the new year, the Supreme Court did respond to that. The suggestion in the narrative in the letter was that though things have been made more obviously efficient in a lot of ways and expedient in a lot of ways with electronic filing and electronic remote viewing of court records, was that there was actually a perception by the news media that there was delay in people being able to remotely view court records in some clerks' offices. In response to the News Media Coalition's narrative, the Supreme Court in January of 2019 referred the matter by way of a letter to a joint committee to be assembled by the Florida Courts Technology Commission, also known as the FCTC, and the Rules of Judicial Administration Committee, otherwise known as RJA or RJAC. Some of our attendees today may be members of those committees. On that joint committee, two of our panelists from today, myself and Clerk Tom Hall, former Clerk Hall, were on that joint committee. And what the committee's task was to look into and see whether Rule 2.420 needed to be amended in some way, shape, or form to potentially make more accessible, quicker court records, and which case types that might have been appropriate in and what have you. Let's turn to the next slide, please. That joint committee worked for essentially about a year. The charge was initially about 6 months, but it was such a big issue that needed to be looked at. An extension was granted and the work took most of a year. Ultimately, Mr. Hall, on behalf of the joint committee, made a presentation to the Florida Bar's Board of Governors in December of 2019. And the Board of Governors voted unanimously 44-0 to report to the court that no action was needed with regard to Rule 2.420. Later that same month, the joint committee submitted its written report with a majority and a minority opinion, with the majority recommending that no changes were needed to the rule. Well, then we get into 2020. And as we all know, COVID sort of descended on the world, including the United States, around March of 2020. There was a tremendous flurry of administrative orders flowing from the Florida Supreme Court during 2020, most of which quite understandably dealt with courthouse operations. What sort of activities should continue to happen, which ones needed to be halted, how things were to be done. And that's what most of the world, most of our clerk's offices and the court system, as you guys know, ended up dealing with during the course of 2020. Let's turn the page now to 2021. At the beginning of 2021, as we were sort of living with COVID and how we were going to handle things new and civil cases, sort of moved into the area of remote proceedings and how that was to take place. In January of 2021, the Florida Supreme Court, on its own motion, sua sponte, amended Rule 2.420. And what the court did was change what Clerk Roth described to you before, was that items that are listed in the list of 23 are treated differently than items that are confidential otherwise, but are not on the list, no matter what the case type is. But what the Supreme Court did in January of 2021 is look at carving out a different approach for most civil cases. And let's turn to the page to that and take a look at that. So specifically, in most circuit civil, county civil, and small claims cases, after the court's amendment, the clerk of court shall not be required to designate and maintain information as confidential unless a notice is filed, if we're talking about information on the list of 23, a motion is filed, if we're talking about confidential information other than the list of 23, or the information in question is just deemed confidential by court order, or the case itself is confidential. So this shall not be required to language. Can we go back just a bit to that prior slide? Thank you. That was a key phrase for clerks, because we knew up until that point in time, we had an independent obligation, regardless of what you or your assistants as filers on your behalf did in the way of protecting confirmation, no matter the case type. If the information was on the list of 23, we had to try and catch that. What this did shall not be required to, it prompted a lot of head scratching in all candor among clerks, because the opinion, the written opinion that accompanied the rule change had quite a bit of discussion that said clerks should no longer do this in most circuit civil, county civil, or small claims cases. But the rule said shall not be required to. Well, that begs the question, should we, may we? the clerks actually filed a comment and sought clarification on that from the court, but it decided to leave the language as is. They did not go with clerk shall not. They left the language shall not be required to. So we do have, under the current language, a bit of a murky situation where some clerks have decided that I'm not required to, but I think I need to still protect that. And some clerks are in the situation where, well, the opinion was pretty clear in saying I shouldn't do it anymore. The main point for you all as filers to take away in this regard is you're no longer going to necessarily have that safety net in these case types from clerks as, you know, to use a baseball term, your backstop. The onus is completely on you, the filer, to protect that information. Next slide, please. This is just sort of reiterating some of the things I've talked about here, that the onus is on you all, the filers. Now, here's where it gets much murkier, even as if 2.420 weren't hard enough to understand before mid 2021. Now you kind of have to think about what kind of case do I have here? Do I get the backup protection from clerks in this case or not? Well, while clerks have been removed from that process, arguably, as to most circuit civil, small claims, and county court cases, the rule change did not apply to these listed types of civil cases. We still have that independent responsibility to protect the information on the list of 23 in those cases listed in the middle bullet point there. And then that's what the last bullet point hits on to. Okay. Next slide, please. This is just a different way to present the same information, really. The idea here being that hopefully these are materials you all can access later and refer back to. Maybe this is a different format to explain for you in which civil case types we will have that independent responsibility despite these changes, and which ones we no longer have them in. Same thing here. I'm a big believer, and I got to say it 3 times for somebody to hear it. So that's what this repetition was for. Thank you very much. We'll keep moving. And I did want to say this, the clerks worked hard when these, our statewide association, to help us help you guys when these rules were affected. At these links, we have both some helpful handouts and a video that I would recommend to you or anyone that helps with your e-filing. They're good primers and refreshers on these changes to Rule 2.420. All right, one more thing I want to talk about before we pass the baton again. So the landscape from mid-2021 to the beginning of 2022 was that the rule had changed, but as of that sort of 6 to 8 month period, there had really been no change yet as to the e-filing authority, the portal. In early 2022, the News Media Coalition did file a federal court action in the Northern District of Florida. Judge Mark Walker was the case on the judge on that case, specifically seeking immediate access to civil complaints. The notion being that they should have, that the public and the media, frankly, should have immediate access to civil filings before a clerk even receives those filings from the portal and does anything in the way of processing the case, building it out, putting it on their website, or redacting it in that case. So that was the relief sought. I won't belabor the procedural niceties of the case, but I did want to provide that information for your reflection. We can go on to the next slide. Ultimately in the case, I did want to point out too, so the defendants in the case were one of our clerk colleagues, Clerk Brenda Foreman in Broward County, named in her official capacity as clerk. Clerk Karen Rushing, who is the clerk in Sarasota County, was not named in her capacity as a clerk. She was named in her capacity as chair of the e-filing authority. The other defendant was the e-filing authority itself. There was a procedural issue to be sorted out, whether the proper defendant was the e-filing authority or Clerk Rushing as the chair of it. That got sorted out. The court did enter both a preliminary injunction and then a final order granting injunctive relief to the plaintiffs. The parties then had to figure out how this was going to actually work and happen. And it was a collaborative process where the clerks worked with the plaintiffs on this and the e-filing authority, and in short order came up with a solution that satisfied the court, which was to make filings, and we're going to get into this graphically in the upcoming slides in just a bit, these civil filings immediately accessible if they were designated as filings containing no confidential information. This last bullet point, I think, is key. There had been some case law throughout the country and other states where in some limited circumstances, certain courts had been ordered to make filings immediately accessible. The dynamic in Florida is a little different with the state court filing system and everything that you e-file going through the portal before it goes out to the respective pertinent clerk. And this is the only known case that we know of to date requiring a third-party vendor, the e-filing authority, and not a court to put state court civil cases out immediately. Let's turn to see what that looks like now in the portal. And before we jump to the next slide, I just wanted to also recommend to you the website there for the e-filing portal. It has a number of worthwhile videos and how-to resources. If you ever have any questions about how do I do this, how, whether I should attach this, how do I make payment, that sort of thing about how to actually navigate the portal, please touch base there first, because I think you can answer probably 90% of your questions before you reach out to any kind of help desk. They're really good videos. All right, so once you enter the portal, you see the bottom left tab there. When you bring up your home page, and I've made it larger than it actually is here, but in the top right corner of sort of your landing home page, once you're logged in, you now have a new button that we've highlighted here with the red oval, Filings Access. If you click in on that, you will see essentially what is below. And this was a snapshot of when I took it, a real-time listing of civil court filings, circuit civil filings, I should say. And you see the blue hyper text on the left and the symbols where you can click on and see these complaints as filed by the filer, not yet received or reviewed by the pertinent clerk. And it's statewide. So you can go in and you have every county in the state. This goes back 5 days. They stay up 5 days before they come down. So I may be making this point too overtly, too implicitly. The reality why we're having this conversation today is if you don't protect information suitably, it's going to be there and accessibly immediately and will not be protected. But let's look at what triggers that. Next slide. So up until these changes were made to the portal last year, you had disclaimer language, which reminded you about 2.420, saying, hey, if you've got confidential information, remember, you're supposed to file a notice or a motion, but you didn't have to expressly do anything with that. You could press forward with your filing. You probably got used to seeing it. You may or may not have read it when you did each filing. Now, as you know, if you routinely file as an attorney or on behalf of an attorney, you have to expressly designate one of these radio buttons, whether there's no confidential information or whether your filing, your complaint, your pleading is accompanied by a notice or a motion. How you choose in these buttons will determine what goes in that queue of immediately accessible filings. And when you say none, that's where that list is generated from. Okay. Let's see how we're doing on questions at this point.
So we don't have, we have a comment in the queue. Says version 11 of the access security matrix removed medical malpractice cases from the VOR required under circuit civil private case types. The current ASM still has it excluded. I think that is why so many answered the poll the way they did.
Okay, helpful.
We don't have any other questions in the queue. Amy's been doing a great job of answering those as they come up.
Thank you, Amy.
Can I add, I know somebody just posted something. I haven't read that, but can I just dovetail
Please.
on something Clerk Carroll just said that I just want to reemphasize is that link that he showed you when you land on the portal's page, that is what the press, that is what anybody data mining is going to look at. So we get in our office, sometimes attorneys or their staff will call us and say, I just mistakenly filed when I filed the new complaint, I mistakenly attached an exhibit. It was our internal billing or something was wrong. Can you pend it back to us? Sure, we can pend it back to you once we get it, but it's already out there. So when you file a new complaint, understand that it is going immediately over to this other site for anybody to see for 5 days. I can pend it back to you, but it doesn't matter. It may not be on the official court record, but it's out there in the public. So please keep that in mind. The other thing I would like to say is we were hoping also that legal assistants and paralegals are on this call as well. If you don't have your assistant or paralegal or other staff members who do your filing watching this with you, I would highly recommend that you have them watch the video of this. Because if you're not doing the filing and they need to have this information because they're filing on your behalf. And if something goes out, it's not their problem, it's your problem. So, and Tom will get into the malpractice portion of that, but I just want to emphasize that I know there, everybody has turnover and everybody's bringing in new staff. Make sure that they understand what it means when they're checking that radio button.
There have been a question. Thank you, Amy. I appreciate that. And I appreciate you emphasizing the significance of that. There are a few questions coming in that are of a similar motion. And those are good questions because I talked about if you select the top button in the portal, that sort of tees up what is immediately accessible. If you select one of the bottom two and you have a motion or a notice accompanying your filing, that's not going to slow down a clerk's processing of your filings. It's just going to keep it from being immediately accessible on the portal. They will receive their date stamps from the portal when filed, regardless of which approach you would take there.
So I think for time's sake, we may just answer the remaining questions in the queue just directly offline and just keep on going with the presentation. I will say we did have one comment about some folks aren't able to see the survey results to some of the questions. So if there are any other surveys coming up, if you could just read out the results as you present them.
Okay, thank you, Patrick. All right, well, I will pass the reins on to Ms. Foreman now. She is one of our absolute rock stars in clerk world. We were joyous to have her join our larger clerk family, and we just appreciate her expertise. Take it away, Amy.
Thanks, Clerk Carroll. I appreciate that. I joined the clerk's office in 2019 after working for the court system for 12 years. So I love being part of the clerk family. So thanks. So I'm going to talk about what does 2.420 look like in real life. And what we're going to cover is something that Clerk Carroll mentioned are these how-to e-file videos. And then the bulk of this is going to be notices versus motions. When do you use a notice? When do you use a motion? And then what happens when the legislature gets together, passes new exemptions? What does that mean for the court record? Because remember what Clerk Roth said in the Akey case, the legislature does not govern court records. That's the judicial branch because of separation of power. So you'll see how all of the previous speakers, their topics come into play here. So next slide, please. we're going to ask this question. You don't have to type your answer in the chat. They will pop up again. I'm just curious, how many of you have used the resources, videos, the manuals that are available on the e-filing authority's website, the website that Clerk Harold had mentioned? Have you used them before? Have you gone on and watched the tutorials? Do you call your clerk's office saying, hey, I haven't watched them because I called the clerk's office and say, can you help me e-file? Really want you to use those videos. They're really helpful. So another 5 seconds, if you can just check yes or no, you've used them or you haven't. Okay, so the results are in. And 44% of you have used them and 56% of you have not. So 88 of those of you voting used them and 110 have not. So I know you can't answer me, but I'm talking sort of as if you were. Please go look at them now, and there should be no reason why you don't. They break them down into little vignettes and you can watch them. Again, another great tool and resource when you have new staff come on board. Okay, next slide. So this is what it looks like. So when you go to the My Florida Court Access, myflcourtaccess.com, you go in the upper right, how to, then you go down to the training videos, and then here are some of the choices that you have. Okay, so again, just a little, you can read them, you can, while we're talking, use your, if you have 2 screens, go on your second screen and start scrolling. Okay, next slide. All right, so this is a little bit of a longer question. Again, it will pop up for you to answer. So let's just walk through this. You represent a client and they're a law enforcement officer. Your client, the law enforcement officer, has been arrested for DUI. The law enforcement officer's address is in the public court record, but we all know it's confidential under 119. So to make the law enforcement officer's address not viewable by the public, would you, A, call the clerk's office and direct them to redact it? And again, this will pop up in a second. B, file a notice of confidential information within court record. C, file a motion to determine the confidentiality of court record. Or D, call a friend because you have absolutely no idea what you should be doing. So if we can pop that up so that people can vote. So do you call us and tell us to redact it? You file a notice, file a motion, or call a friend? Okay, another 5 seconds. Okay, do you want to close the poll? Okay, so 2 of you say call the clerk's office and direct them. No, that's not right. Call a friend. Great help. There are 5 of you who said that, but that could be true. And I'm glad at least you're reaching out to somebody. 59% of you, or 138 of you, said to file a notice of confidential information. And 38% of you, or 87 of the 232 voting, said you file a motion. So it's either really the notice or the motion, and we're going to talk about which one. I'm not going to give you the answer yet, but we are going to answer that in a minute. So if I can close out the poll. And next slide, please. Okay. So what you have to think about is, again, once that document hits the court record, there's confidential information in it. It could be any of those 23 categories that Clerk Roth had shown you, and I have it in one of my slides as well. Files themselves or case types that are already confidential, nobody can see except the attorney of record. So adoptions, juvenile delinquency, juvenile dependency, the case types, you don't have to worry about filing a notice or a motion. They're already locked down. But what if you had information about a sexually transmissible disease? What about if you had information with a social security number, or any of the tuberculosis is another one of the 23. If you have information that is within those 23 categories, it includes some reports in guardianship, it includes some reports in some criminal cases. All you have to do is either file, you file a notice of confidential information, and you either say that the document is confidential, such as the PSI report or whatever the guardianship report. There are certain reports, I don't have them right in front of me, but there are certain ones that will be automatically confidential. You file a notice and you tell us to keep that confidential. Or you tell us in the document there is confidential information pertaining to, and you list where it is. Now, we don't want you to say which provision it's under, because if you file a notice and you say there's information regarding a sexually transmissible disease, then everybody is going to know why your client is filing this, and we don't want that out there. But you file a notice and you say there's confidential information under 2.420 D1B, you can skip the category, located on page 5, paragraph 2, or page 5, line 12, and you tell us, and then we will look at it. And we'll say, yes, that is correct. That is one of the 23 categories, because our clerks have that list in front of them. And they'll say, yes, and we're going to take it and we're going to redact it because you told us to, and it matches one of the 23. So we review your notice. We ensure that it falls within the 23 categories. So if it is, we're going to maintain that. Now, we're not going to lock down the whole document, because if it's just a social security number, we're going to redact the social security number. The rest of the document is out there because, again, it's the least minimally protected. So it's what you protect. Public records, public access governs. But if you say, well, I'll file a notice. It's a law enforcement officer's address. He's my client. He just got arrested for DUI. Our clerks are going to look at that and say, I've looked at the 23. Doesn't say anything about a law enforcement officer's address. Doesn't say anything about a judge's address. Doesn't say anything about anybody's address. Now it does talk about victims of crimes, but let's talk about the police and your client. Yes, it is confidential under 119, but as the previous speakers have stated, that doesn't translate to a court record unless the Supreme Court says so. So it's not one of the 23. So what we would do as the clerk's office is we look at it, and within 5 business days, we're going to send it back and say, this is not one of the 23 categories. A police officer's address is not one of the 23. Filer, you have 10 days to file a motion. We will lock it down. We're going to keep this confidential because we want you to have 10 days to look at it. But in 10 days, it's going to be public. Why? Because the police officer's address is not one of the 23. It may be confidential under a different provision of the rule, but not under D1B, subsections 1 through 23. That's when a notice. That is when the clerk can make something confidential without a trial judge telling us to, because the Supreme Court already has. It's one of the 23. We are ministerial officers. We do not have discretion. We look at it. If it's in the 23, great. If it's not, you need to file a motion. So next slide, please. So when then is a motion required? Well, just like I said, if we penned something back to you because it's not one of the 23, but you believe that this should just not be in the public record, it's a trade secret. There's another provision under federal law, state law, case law that says this is confidential, then you file a motion. And then the second bullet point is you can do that anyways. You don't have to precede that with a notice. If you know that you have a trade secret and you know that you're going to have to file something that uncovers it, file a motion saying it's under 2.420 D1C9 or C9. Okay, and I'm going to show you that slide. Once we get that motion, we are going to lock down that document, not just that little line within it, but the whole document until we get an order from the court telling us what to do with it. Okay, notice one of the 23, motion, everything else. So next slide. So this is where I was talking about is 2.420C789. So all records made confidential under Florida and US Constitution and Florida law, federal law. So there's something in the federal law that says this information is confidential. If you file a notice It's not one of the 23. We're going to send it back to you and say, file a motion. C8, all records presently deemed to be confidential by court rule, including the rules to the admission to the bar, Florida statute, prior case law, rules of the JQC. And then 9 is really, to me, the catch-all. Any court record determined to be confidential in case decision or court rule on the grounds that the confidentiality is required to prevent a serious and imminent threat to the fair, impartial, and orderly administration of justice, protect trade secrets, protect a compelling governmental interest, obtain evidence to determine legal issues in a case, avoid substantial injury to innocent third parties, avoid substantial injury to a party by disclosure of the matters protected by common law or privacy rights, and comply with established public policy set forth in the Florida or U.S. Constitution, statutes, Florida rules, or case law. That could be anything. When that happens, you file a motion saying that the information should be kept confidential pursuant to State versus Jones 24 Southern 3rd, whatever the site is, and the judge is going to decide. You set it for hearing. The court says, clerk, keep this confidential, or keep this page confidential, or redact this information. The court will tell us what to do. Again, 23, we have the independent ability to do it. Anything else, we don't. So next slide. So what are the 23? Here they are. Chapter 39 records, we already know that dependency, the whole file's locked down. Adoption records, locked down. But if you have a social security, bank account, charge account number, okay, any of that, you have to tell us. HIV test results. If you have a family law case and you want to talk about how your client got HIV because their ex-spouse had an affair, that is one of the 23. You file a notice with that motion. You tell us it's on page 5, paragraph 12. We'll redact it because we'll see that you're talking about HIV. We can do that. So the next slide is the remaining of the 23. Okay, this is taken right out of the February 2nd, 2023 rule book. You can go online, go to the Florida bar, you go to the rules, it's free. You can download the PDF of this and you'll have all of your 23 categories. Okay, the pre-sentence investigation report under the rules of criminal procedure, we go to that and say, okay, that's where it's located. That's where I see it. File a notice, we'll lock it down. Now, some of our criminal clerks, because we also have the dual ability, would just lock it down. But it's, remember, you have a co-responsibility to let us know. So next slide, please. So what does the notice look like? In the appendix to the rule, the Supreme Court has given you an example. So you don't even have to create it. It's the entire document, a portion of the document. Where is it? You have to know your clerk's office. There are 67 clerks. Some clerk's offices are going to want the page and the line number. Some other clerk's offices may just request the page number. Please do not file a notice and say that there's crime victim or there's a victim of sexual assault located in the document. We're not going to read the 300-page complaint with all of the exhibits. You need to tell us. We will append it back to you. You have to let us know where we're looking. And if you tell us it's on page 10, paragraph 4, page 12, paragraph 5, and page 16, we're not looking at page 24. So if you miss it, we're not going to catch it. For those of us that have the scanning software, it looks for numbers. It does not look for names. So Tom's going to talk about what happens if you don't do this and the malpractice that you could be committing. You must make sure that that confidential information is listed, the page number, so we can find it. All right, next slide. So here's an example of a notice that wasn't part of the form. This is just what a lawyer drafted up. Notice of confidential information within court filing. I'm filing this, and they write where it's located, and it's composite exhibit C, the account statement. It's on the top of page 1 of 3 and bottom of page 1 of 3 and top of page 3 of 3. They are telling us where the account information is located so we can redact it. That's what we need. Okay, next slide. So the other thing that's interesting is you have the ability and the right to file a notice when your opposing party files something where they should have filed a notice and they didn't. Maybe they were sloppy. Maybe they committed malpractice. Maybe they were doing it because they were being a little bit unethical. Okay. You have the ability to file a notice on a document that another party filed. If it's one of the 23, we'll go back and we'll look at it. You'll have to let us know that docket entry 21 filed on February 21st, 2023, page 5, line 10. This information is one of the 23 categories. You let us know, we'll look at it, we compare, yes, one of the 23 categories, we'll redact it. If not, we're going to send it back to you, file your motion, but we lock it down. Next slide, please. So this is what it looks like when we say, I'm sorry, but it's not one of the 23. Okay, so this is all part of that same case. They filed a notice saying that this counterclaim should have been made confidential. We send it back and say, you're hereby notified that the notice of confidential information within court file on the second amended counterclaim is not facially subject to confidentiality under 2.420 D2. Here's your notice. You're going to have 10 days to file your motion. Okay, so next slide. And this is what they did. They filed a motion after we sent that notice back. And then they said exactly what happened, where it was in the counterclaim, why all of this information shouldn't be in the public record. Then this gets set for hearing and we wait for the court to tell us what to do. But in the meantime, that counterclaim gets locked down pending the court's determination. So next slide. Okay, so that's where we are with the notice versus a motion. What happens when the legislature passes new exemptions that are not part of the 23? So this past year and this current year, there were 4. So I just want to go through what happened. So Senate Bill 1614 in 2022 amended Florida Statute 31650. And it says that driver information contained on a uniform traffic citation, including the date of birth, driver's license number, address, and telephone number are confidential. Or I'm sorry, actually not confidential, they're exempt. They didn't use the word confidential, they said exempt. So you now have a provision that says, okay, we could make this locked down, but it's not part of the 23. It went to the RJA, the Rules of General Practice and Judicial Administration Committee, and they said, you know what, it's a little too complicated because it's exempt. How is a clerk going to know on each one? So if you have a client that wants their DOB and DL number and address and telephone number kept exempt from public view, file a motion. We lock down that UTC, and then the court, you'll have to have a hearing and the court will rule. Same thing with Senate Bill 1304 that talked about that amended statute 662.1465 on family trust company proceedings. The legislature directs the clerk to keep certain court records of the family trust company litigation separate from the other records, not open to public inspection. We don't know which records, we don't know which things. You're going to have to tell us. File a motion. It's not one of the 23. We lock it down. You have a court hearing. You let us know. Same thing with the structured settlement information on annuity contract payees. There's personal identifying information. File your motion. And this year, just like judges and law enforcement officers and state attorneys and some DCF employees, judicial assistants hasn't been signed yet, but it's been enrolled. Will say that their information will be kept confidential. Well, I don't know who a judicial assistant is. I don't know who the judges are. I don't know who law enforcement officers are. If you have a case where a JA is your client, make sure you file a motion identifying which document and where, and the court will tell us to keep it. And 99.9 times out of 100, of course they are, because there's a statute that allows for it, and they're going to direct us to keep it confidential. So next slide. Okay, I'm at the questions. Okay. I'm sorry if I talk fast. I just get very animated over this. As you can tell, we all do.
No, you're great. I think we're going to keep moving forward for time's sake and then try
Okay,
to.
I'll answer them.
At the end.
Okay.
Okay, great.
So I'm going to hand it off now to Tom. And Tom's going to talk about the practical takeaways and what this means from a malpractice point of view.
Thank you, Amy. And I've spoken on the subject quite a bit, and I would just like to comment that the questions we're getting are really good. And also there's been some people who obviously know some about this subject because there have been some really good comments that have helped actually clarify a couple of things that we said. So I appreciate that from everybody. Let me give a little context of what I'm going to do before I actually get into it. I'm going to talk about some cases where lawyers have been disciplined for releasing client confidential information. I'm going to talk about some cases where people have been sued for that, all those sorts of things. I want to make it clear that those cases do not involve exactly what we're talking about here, where somebody in a filing simply forgets and overlooks that there's client confidential information in that pleading, and they forget to check the little button that says, they forget to check the little button, and then it goes out. I also want to just comment about the importance of this change that was brought about by the federal case. Both Amy and Greg have talked about it, but you have to understand how absolutely that really just changed the entire ballgame. Before, things went there, even if you missed it and the clerk didn't catch it, or it was not the kind of thing the clerk would catch, it's still there in the court file. You have to go court file by court file by court file to look at it. Now, civil complaints where that top button is not checked, go to this other website immediately before the clerk looks at it, and it's there and available. It's there for anybody who registers with the portal to be able to look at. And we know there are people looking. There are lots of people looking. And they get this information right away. So it really does change what's happened. And in addition, we haven't talked about, there's another provision now in effect in the portal that if you want to, if you have a case you want to keep track of, you can file a notice asking to be notified, not just of the complaint, but every single thing that gets filed in that case. And we know that there are a lot of people already. I think the last number I heard a couple of weeks ago, there's about 600 people who've actually registered to receive notice of everything filed in particular cases. So the stuff that used to be, there's a term that's floated around for years and years, practical obscurity. That stuff in court files, it's there, but it's practically obscure because you have to go look at each individual file. That's simply not the case in Florida anymore. Now it goes directly out to a website that's easy to look at and easy to get. So with that little preface, let me make one more thing about this. One of the reasons that we're talking about this a lot is this is a complicated rule. There's 3 rules involved. They're all complicated. None of them are actually easy to interpret. The 2.420 is the longest rule in the rule book. We tried to shorten it a few years ago, and the court rejected it for a number of reasons, and we probably will take a shot at it again. But it's a hard rule to read. It's hard to interpret. So it's really important that you try to understand these rules. The other thing I'm going to mention that I'm in the process of writing a Bar Journal article that will probably be published in a couple of months about these exact issues. And we'll probably go into a lot more detail in that than we can really go into here where we're talking and we've got a limited time frame. So I just want to let you know that we're working on that and that will be coming out soon, we hope. But with that, let me ask you the last question we're going to ask. So the question is, you're representing a client who's contracted tuberculosis during a hospital stay. So on behalf of your client, you're going to sue the hospital for negligence, and the complaint alleges that your client has the disease a number of times. So when you file the complaint, you should file a motion asking the judge to order the information be kept confidential, file a notice instructing the clerk to keep the information confidential, show the information to be disclosed because your client says it's okay to disclose the information. Redact the information from the complaint in all filings because the information is confidential under state law, or email opposing counsel and explain your client has the disease. You're going to keep it confidential, but you'll make sure that they get everything they need to get if they want to contest that the client has tuberculosis. So with that, we'll start taking answers. And one thing I wanted to reiterate too, that I wanted to pick up on, and I think Laura may have said this, but I think it's really important, you know, while we're continuing to wait on answers, is if something is confidential and you file it the first time and you give the clerk the notice and they treat it as confidential, that doesn't mean they're going to catch it after that. Every time you file something that has confidential information, if it's one of the 23, you have to file the notice every single time. So I think that's probably enough time. Let's go ahead and close and see what answers we get. So this question is a little tricky in this sense. And I'll go over the answers and talk about each one of them real quickly. But one of the things about this rule is that it doesn't cover at all what you do when you have confidential information of your client that your client is okay with them disclosing. If it's one of those 23, and you let's say you file the complaint and you say they have tuberculosis, the clerk is probably going to they are going to redact it because they're responsible for doing so. So the real answer normally would be file the notice. If you want to keep it confidential, you just file that notice. It's one of the 23, the clerk will keep it confidential. If in fact your client says it's okay to disclose it, sometimes in that kind of litigation, they will say it's not okay. It's not only okay to disclose it. I want to disclose it because I want to show that the hospital was negligent and I should have never got tuberculosis. If you're going to do that, because it's one of the 23, the clerk is probably going to redact it every time. So what I would do in this particular case, even though normally the answer of file the notice is the right one, what I would probably do in this case is I would do something that's not actually among the choices, and I would file a motion asking that my client has decided it's okay to reveal he has tuberculosis and ask the judge to enter an order directing the clerk to not redact it every time. So that's where we are, and let's go on to the next slide. So the key thing about this, and let me make one more limitation or talk about what I'm going to do and put this in context. I'm going to talk about only if you release client confidential information, because because of this particular rule that you have this obligation. You still have an obligation when you file stuff and there's other people's confidential information in there. You still have an obligation to protect it. I'm not going to talk about that because that presents a different sort of situation, and we want to talk about what might happen if it's client information because you have a specific obligation. This is rules regulating the Florida Bar 4-1.6 confidential of information. You can see what it says there. You must not reveal information relating to a client's representation except as in B, C, and D, and I'll talk about those in a second. And the comment to that rule is it's a fundamental principle of the client relationship, lawyer-client relationship, that unless there's informed consent, you cannot really release that information. The other thing that I didn't quote in there, in that subsection or subdivision E of that same rule, and it says inadvertent disclosure of information. A lawyer must make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to a client's representation. So clearly the bar rules put an obligation on you to keep your client's information confidential, and that includes in court files. I want to move on to the next slide, but as while we're doing that, I want to just also have a real sort of awareness of what's happened here. The bar itself, and the cases you'll see, the cases I'm going to talk about, don't really, I was unable to find any case where they were talking about this exact situation where you file a pleading, you don't check the box and something is disclosed. But that's only because, as we've been talking about, that's only a recent obligation that you have to check that little box and not button and not disclose it. But the bar is really aware of the sort of lack of compliance that's happening, where lawyers are filing so many things but not identifying the confidential information, and they become aware of that. And that's one of the reasons that we're doing the seminar is the bar was interested in making sure that lawyers really knew about this because it is becoming an issue. So the first thing that can happen is one of the sort of three things that can happen to you if you don't comply. And one of those is simply sanctions by the judge who is presiding over the case. Rule 2.420 specifically says you can be sanctioned if you do it. As you can see there, though, it says you have to be given an opportunity to respond, and the judge has to make a filing that it was done in bad faith. There are 6 subdivisions under the rule that say the kinds of things you can do that will get you sanctioned. The one that I think we need to focus on here, not because it's actually the most common, but because it's the one that will, if you fail to do this, it will lead to the confidential information being sent out to that other website that we're talking about and be immediately available to anybody, and they can copy it and keep it, et cetera, et cetera. And that is fails to file the notice of confidential information within the court filing. If you fail to do that, you're subject to sanctions. I haven't found a case where somebody's been sanctioned for this yet. But I think given what's happening right now and the awareness of this issue, I think you will start seeing that more as we go along, if we can move along. So bar discipline. In addition to being sanctioned by the judge, you are subject to bar discipline. I've cited a couple of cases here. As I said, they're not exactly this kind of thing. This was more where, while litigation was going on, things were submitted that contained information as part of the litigation that weren't identified. And there's some reasons they offer in this. This is just a short excerpt from the opinion. They offer reasons why they did it, et cetera, et cetera. But ultimately, the respondent was suspended for 30 days because they had failed, because they had disclosed this financial information of a client. So 30 days is, it's the least you can get without having to sort of reapply. If you get 31 days, you have to reapply. So you want to, it's a pretty stiff sentence to get for what happened. So next slide. And this is bar discipline as well. This is if you read this whole case, this is a really interesting one. And this goes into some of the exceptions that are in B, C, and D of the rule. And one of the things that you can do is you can disclose client confidential information when you have to as part of the case to sort of prove the case, defend the case, that sort of thing. Here, there was a fight going on over some trade secrets and some who had the rights to stuff. And what happened is the lawyer put in some trade secrets of the clients as part of actually having to prove the case. But what they did was they put in some that ultimately the court ruled they didn't have to put in. So they made a judgment call, it seems to me, if you go read the whole case, about I need to put this in to help my client, to help prove that, you know, they're going to win or they're not going to lose, whatever. But they put in a little too much, more than they actually needed to do, and they ended up being subject to bar discipline. So if we can get the next one. And this is the one that I think in terms of malpractice, because it can be malpractice. If you disclose client confidential information negligently, that can be malpractice. The one that I think that lawyers really need to worry about is this case. It has not been applied to lawyers yet. This case involved a psychotherapist who gave out confidential information about their client that they got as part of that psychotherapist patient relationship. And the court ultimately, they held that the impact rule, which you normally have to do in a case of intentional infliction of emotional distress, did not apply because of the breach of client confidentiality. And the language there that I quote at the bottom, where they talk about the trust and confidence between the parties and the trust accepted by others, etc. If you read the whole case, the language they talk about the psychotherapist's relationship with their clients and the obligation to protect confidential information, that language is almost word for word the language that exists about what lawyers have that fiduciary relationship with their clients and not to release their client confidential information. So ultimately, I can see that if something really bad got out, you really would subject yourself to a possible malpractice case. And if we could move on. So what might save you? First, generally the bar will not discipline for a single isolated incident of malpractice. It's a standing board policy. There's a link at the bottom that will take you to all those board policies. But this basically says, if you do it once, they're not going to discipline you. You sort of get one free disclosure, I guess, is what's going to happen. But so that if you just do it once and not a bunch of times, you're probably not going to get disciplined. Next. So to be sanctioned under 2.420, you have to have, as it said in the rule, there has to be a finding of bad faith. If you read the cases on bad faith in multiple different kinds of situations, that one where lawyers are being sanctioned by the judge for something they've done in the case, there has to be a finding of bad faith. In bad faith insurance cases, there has to be this finding of bad faith. In each of those cases, it's really important to note that simple negligence is not enough to constitute bad faith. The last case there was a lot of negligence, and basically, as I said, no matter how much negligence there is, it doesn't prove bad faith. It seems like a crazy result to me, candidly, but that's the way it is right now. You have to show something beyond negligence to be found guilty of bad faith, which really does make it hard to sanction somebody under 2.420. Next. So that's it for now. I would say that we're a little short on time, and I would urge that once we get the Bar Journal done, that people read that. In that article, we're going to go a lot more into the whole issue of negligence, bar discipline, sanctions by the court. There's going to be a much more extensive discussion of that in there. And so, I'd urge you, once it gets out, that you look at that if you want to get a much more in-depth of this. We're just sort of covering the surface right here just to point out that it definitely is possible that you can subject yourself to all of those things if you are negligent in not protecting your client's information. So with that, if there's any questions, we'll try to answer them. And this goes to questions not just about what I just covered, but questions about anything. We want to try to deal with whatever you do on that. But we've got a couple of more slides we want to cover. And I think we've only got about 5 more minutes left. And so I would say that question is, it's not one directed at us. So at this point, I'm going to pass it back to Clerk Timon to sort of wrap it up for us.
Great. Thank you so much. And thank you, everyone. As I mentioned in my introduction, we talked about the governance and the processes related to access to sensitive or confidential information within court records, including applicable court rules, Florida statutes, case law, and how they relate to the practice of law and access to court records. As we conclude, we summarize some of the information that we provided. We all recognize that it's a lot of information. It may be new to some of you. Some of you may be very experienced in these areas, but we hope that some of these tips may assist you in future civil filings. So here's a little cheat sheet. The first on this cheat sheet provides a high-level overview of what type of notice or motion would need to accompany a particular filing. For example, if you're pleading as sensitive information, you, as the filer, would need to redact or minimize that information prior to filing, pursuant to Rule 4 or 2.425. Remember, as we continue to say, in these cases, the clerk has no responsibility for reviewing and redacting this information independently. We also want to point out the revised civil cover sheet. This is another helpful tool and a good reminder to you as you're working through your cases. This document includes a question regarding whether or not the case involves an allegation of sexual abuse. This change came about at the request of the clerks because allegations of sexual abuse may require redaction independently by the clerk. However, we often had to read entire filings to try to identify these situations because they're really not a specific case type that could be readily identified. As a result, clerks were experiencing significant workload and cost impacts, including potential liability, trying to locate this information. As you've heard today, please remember, regardless, the filer still has an independent responsibility to file the accompanying notice of confidential information within court records. And we have a one-page summary on how to avoid the most common problems. So I'm going to give you the best way to avoid the most common problems. First and foremost, please read the rules. And while I won't read each of these points to you, I would also stress the importance of training your staff, as you heard today, in the requirements of the rules. We greatly appreciate your time. There were so many great questions that were posted. I know that we tried to respond to all of them. Our contact information will be on the last slide if you have additional questions. And I know that by working together, we really can be successful in protecting our community, constituents, and clients from the public release of their confidential or protected personal information. We can also balance those very, very important protections, privacy and access, with the public's right to certain information contained in court records. And thank you so much to our presenters, along with our professional teams at the Florida Bar and the Florida Court Clerks and Comptrollers for sharing their knowledge and expertise. I know we have 2 minutes to spare, so we made it. I know it's a little tight for everyone. I do want to mention the CLE number 7546. No one has asked that yet, but I anticipated those questions. And I think, I'm not sure on the exact process, but I believe there's some more questions in the queue. So once we conclude this, I think some of those can still be answered. If not, again, the last slide gives our specific contact information. And I know any or all of us would be more than happy to either answer your questions directly or make sure that we put you in contact with someone who can. So again, thank you very much for attending this important presentation. As I mentioned in the beginning, I think this benefits all of us, and we're kind of all in this together. So thank you very much for your time.
Clerk Timon, can I just answer, since it's easier to talk one of the questions
Sure.
through than to write in, is from Desiree. So the question is, many times I'm unable to look at file documents online.
Mhm.
So I provide a signed notarized statement to the clerk and receive a code to use the attorney portal. And I don't know which county you're in, and you're talking about as an attorney, this can cause problems with research. I'll talk about it from the Palm Beach view. There's an access security matrix, and ironically, an attorney called me this morning and asked me basically the same question: how do I get to see a family law case online? And under the access security matrix, there's certain cases that cannot be viewed online to the public but if you're a registered user, you can. And that's all governed by the ASM. So that's why they're asking you to register. I don't know what county, but what will happen is you can always see these documents at the clerk's office through the computers internally in the building. You don't have to actually pull the file. There are computers, but if you're a registered user, you'll be able to see more things. And that's why they ask that, because the Supreme Court says certain documents like family documents and probate documents cannot be seen online.
Great, thank you, Amy. And that registered user access is without cost. It is free, so.
And will the PowerPoint be available? I don't think we're going to be sending it. We're going to just send it out to everybody who's registered. No.
Jenny, maybe you could help with this, or Tom?
I thought it was going to be sent out.
Yes.
Yeah, the plan is to post the PowerPoint slides along with the video on the trial lawyer section website, and we will email the link to all attendees as soon as it's available.
Wonderful, thank you.
Thank you.
Any other quick questions that the participants are able to respond to quickly?
I don't know if the clerk's on the call. Desiree was saying in Hernando County, she cannot see anything on public view. So I don't know how their public access is set up. I don't know if any of the clerks on the call know Hernando County.
Perhaps if Desiree, afterwards, you have our email addresses. If you can send us your contact information, we'll pass that along to the Hernando clerk and maybe they can talk to you about that or contact you about that. If you would do that for us, Desiree.
Michelle Edwards said you can also call her as well. She's from Hernando. Who's on?
Oh, okay, great. There you are. Okay,
Thank you, everyone.
great. Thank you, everyone.
Thanks.